Good evening, YouTube. It is currently about 6:10 p.m. Thursday, June 23rd, and I'm just left Topeka, Kansas, where I dropped off a load of lumber at Menards. I picked this load of lumber up at the Menards Distribution Center in Valley, Nebraska. Man, that place is huge. They have train tracks going through the distribution center because they get some of their deliveries by rail. And I've been told that it takes a lot of time. It takes a long time to get loaded there, especially if you have multiple stops. But I had no problem, and didn't take long at all, maybe 15 or 20 minutes. But I only had one stop to make. I guess there are multiple loading stations, and I was able to get loaded just with one stop, which was fantastic. They did overload me by a little bit. Their scale said I weighed about 82,700 pounds. So I went back and they took off a couple bundles, and that put me at a little under 79,000 pounds. But man, I'll tell you what though, when I got done strapping, when I got done securing my load, there was a line to get into the loading area. Probably at least 5 or 6 trucks waiting in line. So I'm glad I did get there when I got there and got in and out. But then I made the short trip down to Topeka, and I read an article while I was getting unloaded, and I kind of want to talk about that article. It's regarding a Supreme Court ruling where they said that a cop could not be sued for a Fifth Amendment violation, which is self-incrimination, because he failed to read a person the Miranda warning. Basically, what I got from the brief was that basically Miranda is a part of the Fifth Amendment, but it is not the Fifth Amendment. I kind of agree with that kind of stuff, but I will say that if a cop knowingly does something wrong, then yeah, they need to be held accountable internally, and hopefully if this cop did do something purposely wrong, then hopefully, or even just negligent, hopefully his department took some kind of action and trained him the correct way, because I did read a little bit about the case, and it sounded like there was an issue with Miranda, but only in part of the case. Basically, the suspect was accused of sexual assault, and ultimately the cop got a confession and an apology note from the suspect. Now, I'm kind of going to put myself in the cop's shoes, okay? If I would have somebody come to me and say, hey, detective, this person grabbed me by my genitals, because I think that's what this case was. I think it was he grabbed somebody by the genitals. So if they came to me and said, hey, detective, John grabbed me by my genitals and I need to make a report, I'd get all the information that I need from that person, and then I'd go to John and say, hey, John, this person says you grabbed him by the genitals. Do you want to give a statement? If John goes into confession mode, yeah, I mean, that's a good confession. I don't have to read Miranda because he's not in custody. Okay, Miranda requires 2 things. It requires that somebody be in custody, and it requires that they be that there be an interrogation. Okay, I'm only getting a little bit of information for the statement. Plus, my question to John is, do you want to give a statement? If he goes into full confession mode, pretty much no matter what, I'm good in that. Now, where I would have to read Miranda is if he were to give the confession, say, yeah, I grabbed that person by the genitals and I'm sorry. Well, if I wanted to ask questions after that or try and gather evidence after that regarding John himself, then I got to read Miranda. So if I want John to write an apology note that will be collected as evidence, I need to read him Miranda at that point. And I think that's where the officer went wrong, was he got the good information that he needed to make the arrest, and but then didn't read Miranda when he continued the investigation. And that's where it needed to come in. And now what I will tell you is just simply one person saying another person grabbed him by the genitals. Yeah, if there's no evidence, you know, you'd be hard pressed to make an arrest. I'm not going to say you can't make an arrest, but if I was literally have just that situation where one person says another person grabbed him by the genitals, and there is no other kind of evidence like video surveillance, text messages between the victim and the suspect, where the suspect confessed their wrongdoing, or an independent witness, then yeah, you know, I probably won't be able to make an arrest at that point. Now, if John were to grab somebody by the genitals and there be, let's say, some kind of evidence to where I could definitely make an arrest, nothing stops me also from approaching John saying, hey, so-and-so grabbed you, says you grabbed him by the genitals. Do you want to make a statement? Because my question is, do you want to make a statement? If he goes into full confession mode, that's on him. Still, Miranda doesn't apply, because basically I'm just trying to make a decision on whether or not John is going to be given a ticket, sent to jail, or brought to the police station. So if John were to give a proper answer and say, yes, I would like to give a statement, then I would say, okay, we're going to go to the police station, so I need you to turn around, put your hands behind your back. At this point, you're under arrest. Now, when I get him to the police station and I go to ask him questions about the case, then I'm going to go ahead and read Miranda. But like I said, if he just goes into full confession mode right there on the spot, I'm going to let him talk. And I'm going to let him talk until it is obvious he's done. Because, like I said, that, you know, Miranda doesn't apply, and I don't have to read a Miranda. Now, the problem I had with the article itself was it referred to reading Miranda when somebody's arrested. Okay, well that's not accurate. People get arrested all the time, and Miranda doesn't apply. You know, because like I said, the person has to be arrested, or arrested, and there has to be an interrogation. Okay. I mean, really, if the cop would have said, you know, hey, do you want to give a statement? And he goes into full confession mode, and then when he's done giving a confession, the cop can arrest him right there on the spot, take him to jail without any further conversation. But like I said, where I think he went wrong, and he probably needs to be educated if that's what really happened. Like I said, I'm giving an opinion of what I think happened based off of the information that I got from the article, and I think that I can pretty accurately do that, I believe. But you know, if that's what happened, then yeah, he probably needs to be trained and enlightened, or instructed, or however you want to put it, that once you realize that that person is no longer free to go, you need to read them Miranda before you ask any more questions, or before you attempt to gather evidence from that suspect, and by way of a statement, whether it be oral or written. Anyway, so that's my case about that. Oh, and I guess I want to tell you guys a little bit about Miranda thing that I had once in a case. I was assisting in investigating a homicide, and I had interviewed the suspect, and during the interview, the suspect ended up invoking his Miranda rights by way of saying he either wanted to be silent, didn't want to answer any more questions, or he wanted an attorney. Either way, I just stop and I'm done. You know, I don't necessarily, if somebody says, hey, I want an attorney, well, the way it really works in the real world is I stop asking questions. I decide whether or not I can put them in jail with the evidence that I have. If I can, then they get put in jail, and then they are issued or they're provided an attorney, or the opportunity to get their own attorney during the court proceedings. I don't actually provide them with an attorney. Now, I have had people say that they would give a statement with an attorney present, and then I ask them, do you have somebody in mind that you want to call? And that was typically my answer, or that was typically my response when somebody would tell me that they wanted an attorney. But like I said, most of the time they're not going to know who to call or anything like that, and it's not my job to actually provide them the attorney, because that is actually done during the court proceeding. But anyway, so this guy invoked his right to an attorney or to be silent, one of those two things, and I stopped the interview. We leave, and we're still conducting investigations, and this is a homicide, so it's pretty realistic that this guy's going to be in an interview room for a while. Okay, we know he's not free to go, and he can be under arrest at the police station, or he can be under arrest at the jail. And if we got to keep him at the police station for a couple of hours while we're doing investigative work, then that's just what has to be done. Okay, now, the person does have to be given the opportunity for breaks, whether that be a restroom break, a smoke break, or a water fountain break. And if the person's not dangerous, yeah, take them outside and let them smoke. I've done that numerous times. But there might be a time when a person's smoke might be declined. But anyway, and also if we provide them food. I've went out and bought people food before, and sat in an interview room with them and ate my food with them, while we're talking about the case. Because as long as we're providing those things to those people, then it's okay. It is unreasonable to hold somebody for hours without providing them any kind of restroom breaks or anything like that. And if people want to make a phone call, like I said, that's kind of a judgment call. If their phone is evidence, then I really can't provide them with their phone. But I have taken people to my desk before and let them use a phone call, or let them use my phone to make a phone call, because I definitely want to go above and beyond to try and show that I provided that person everything that they asked for and then some, because I don't want to get my statements, or their statements, I guess, suppressed. But anyway, so I keep going off track. So this guy invoked his right, and then he called me back in after a couple of hours. He's like, "Hey, you know what? I want that detective to come back in and talk to me." So I went back in and I talked to him, and I told him, I said, now, and I do remember now, it was an attorney that he asked for. And I told him, I said, now, we were talking before, and you said you wanted to stop because you wanted an attorney. Is that accurate? Yes, I wanted an attorney. But now you've called me back in here, and now you say you don't want an attorney. That is correct. And let me tell you, man, I went over that and re-went over that and went over that and went over that so many times just to make it clear that he requested an attorney and that he wanted me to come back. Nobody asked him if he wanted me to come back. He asked an officer if he could track me down and have me come back and talk to him. And then he gave a confession. Well, the prosecutor in the case was, kind of had a problem with that once she got all my reports, and she was like, "Oh, we're going to lose the statement." I said, "No, we're not going to lose the statement. Oh, you needed to reread Miranda." I said, "No, I don't. There's absolutely nothing in case law that says I needed to reread him Miranda." I said, "In fact, I went above and beyond by discussing clearly that the part where he invoked, and then getting a clear and convincing statement from him that he wants to speak with me further without an attorney." So, she was just all worried that we're going to lose the confession, yada yada. Well, in short, this thing it passed. It passed the motion hearing to suppress the statement, which it didn't even have a special motion hearing to suppress the statement like we have in my county. Everybody gets a hearing to determine whether or not the statement that they gave is admissible. It's almost become a part of the criminal justice process here in my county. That it's not even an extra. But in any case, the statement was went to jury trial, and he was found guilty, or he pled right before jury trial. One of those two things happened. But in any case, we've never lost a statement, and as far as I know, there was never an appeal to the statement, and I stand by my guns that at that time, and I don't know what the current law is right now, just because I have been out of that for over a year now, but I am confident that back then I did not need to reread Miranda, and that I went above and beyond, showing that he wanted to talk to me all voluntarily. So anyway, that's that. If you guys want to start up a conversation, don't hesitate to shoot me a comment, a message, whatever. If you like my videos, like them. If you want to share them, share them. If you don't like them, that's fine too. Like I said, if you want to start a conversation, don't hesitate, because I will talk to almost anybody regarding almost anything. Until next time, you guys have a good day.